May I please, Your Worship? I'd like to mention one unlisted person allowed now.
This is about,
My lord,
the case is about, what is this?
criminal revision petition. Yes, that actually it could.
Revision?
Yes.
No, then in that case, that is to be mentioned before the senior bench. Yes.
My lord, I beg to mention, my lord, praying for unlisted civil revision petition, my lord.
Mentioned before the senior bench, please.
My lord, yes.
My lordship, I beg to mention item number 17, lordship, with a concern from other side, the matter may be released after 2 weeks, lordship. Seven.
Mr.
K. Lawling, lordship.
K. Logan, Land Council for the appellant with the consent of the other side. Praise for adjournment of the matter for 3 weeks.
2 weeks, 2 weeks.
2 weeks. Where list is matter of 2 weeks.
Your Lordship, here I'm for the state. This matter may be fixed that may be given in this case because
One matter to be fixed.
yes, many times it was adjourned
Okay.
by the petitioner. Fixed that may be given.
The accused, the convict is on bail. Or what?
Today's consider
Pray for adjournment, huh? Praise for adjournment for 2 weeks.
yes, 11 June.
Mr. Jitara, additional people has no objection. However, he prays for fixing of the matter as the appellant has taken. No, it's okay. Fix matter as requested by the parties. Let the matter be listed out.
11 June.
11
June.
June. Okay.
Of life.
May I please, my lord? My lord, I beg to mention item number 9, my lord.
Yes.
On behalf of H
Other copy also. With the you have to inform the registry. Okay, Mr. Under section 20C, 27A, 29 of the NDPS Act 1985. Call for the scanned copy of the case diary. Start. Ms. L. Hagen, Banner LPP received notice on behalf of the state respondent. Start. List this matter.
Next
Okay.
week, Lordship, 28th, it's nearby Doimuk PS.
28. Okay.
Right.
Much obliged.
28.
Your Lordship, this is an application filed under section 482 of BNS for granting pre-arrest bail, namely Srimati Meena Bagang. Your Lordship, the complaint was filed on CDPO office Paki Kesang through telephonic call.
Where is the
Paki
allegation?
Kesang.
Where is the FIR allegation?
Lordship, this is a non-FIR case. Case has not been registered. The only complaint has been filed.
What is the allegation in the complaint?
Allegation is that complaining child has been trafficked. Your Lordship, on the very date complaint was received by CDPO, the officers of the CDPO called the petitioner and child will handed over them safely. Now they are in their hometown, Your Honor.
Who is in the hometown? Child.
Child and the parents, Your Lordship. On Your Lordship, on 22/4/2025, another intimation letter was received through WhatsApp by the petitioner, stating that on page number 11, Your Lordship, that is series 11 series, type copy. May I read, Your Honor? With regard to above subject, I'm to inform you that I'm going to Assam for providing medical assistance to my pregnant wife.
Wait. Okay. So there is, I think, these are the name of the children
Yes, Your Lordship.
have been trafficked.
Yes, actually not has been trafficked. The complainant kept the child with the petitioner, Your Lordship, as they were going to Bangalore for a job. On request made by the complainant, they kept the child for some days.
Where is the complaint? He talked about the complaint lodged against the accused applicant.
Yes,
Where is that complaint?
there must be a complaint. There must be a complaint.
Complaint was not being punished, Your Lordship. We asked about the complaint, but actually on that very day, the case has been solved. The only apprehension about the arrest is that on 22/4/2025, this intimation letter was received.
Yeah, you are apprehending arrest in which case? Or for what offense? Where do we find?
Your Lordship, that CDPO has not furnished the complaint copy. They said that
CDPO,
Is
you are
a child-
apprehending arrest by the CDPO.
yes, Your Lordship,
How CDPO
They-
can arrest?
they endorsed police to call the
That is why you have to obtain FIR or the forwarding letter, which the police has taken it as registered it as a FIR, and then you have to mention the offense.
Your Lordship, we seek for the complaint copy, but they didn't provide us.
CDPO, whether the CDPO has the power to arrest.
They've endorsed the police, Your Lordship.
Thereafter only after the endorsement, whether the police has registered the case or not.
Your Lordship, they just
Then on what basis you are apprehending arrest? Can you see the provision? What is the provision? It has to be a non-bailable offense. You should be apprehending arrest in connection with some non-bailable offense alleged against you only. There is no offense. This is only the person informed that he is taking away his children.
Here also, it is mentioned that I am aware that a complaint is lodged against.
Yes, that is
Mrs.
why there must be
Yes,
some.
there must
complaint.
be a complaint. And that complaint was not annexed here.
I think it's premature. You have to either withdraw or you have to annex the copy of the FIR in connection with which you are apprehending at your arrest. And where have you stated that you are apprehending arrest? What, in connection with what? Which case? You are talking about liberty, but then what is the allegation against you?
Only the child has been trafficked, Your Honor.
So that is enough, I think. Is that not enough? Only the child has been trafficked.
Your
That is
Lordship,
enough. Let the case be registered and then you mention the name of the case. What do you do? I think you need to withdraw the case, obtain the copy of the FIR
yes, Your Honor.
against you and then file.
Yes, Your Honor.
Okay. Miss,
Binaki.
Hmm?
Binaki.
Binaki. Land Council for the petitioner wants to withdraw this bail application with liberty to file. FS ipso advice. This bail application is dismissed. Or being withdrawn with liberty is grateful. Okay.
Oblige, Your Honor.
Oblige.
Yes,
My lord. Your Honor, my lord, this application is filed under 528 of BNSS. Quashing and set aside of charge sheet number 86 of 06 dated 26/8/2006, Your Honor. Under 379 of IPC, Your Honor. On the strength of your amicable settlement between both the parties.
so the case is pending before which court?
CGM, Your Honor. Chief
CGM?
Justice.
CGM UPI.
Yes, Your Honor.
What is the status
On CC, Your Honor.
of the trial? Charge framed?
Not, Your Honor.
Not yet. 379.
Yes, Your Honor. Moreover, in this case, Your Honor, stolen item is also recovered and handed over to this complainant, Your Honor.
Case of 2006.
Yes, Your Honor.
Yes, Your Lordship.
And then, so the party,
Your Lordship, otherwise also, since they have already received the stolen vehicle, Your Lordship, I would have not objected to, but then since the court has also to be seen that at what stage the proceeding is, because it's a case of
have you
2006.
annexed the last order passed by the court,
No,
trial court?
No, Your Honor.
This is her, Mr.
S. Nabum, Your Honor.
S.
Nabum.
Hmm. Okay, no one whose name is reflected in the cause list is appearing. Your name is not, your name also is not reflected.
Not reflected, but
That is. Okay.
on S. Nabum, Your Honor.
Otherwise you have filed wakalatnama.
Yes, Your Honor.
Land Council for a petition. Para, this is a joint petition filed by three petitioners. Who is the informant here?
Yeah, Decidenya, Your Honor.
This is Dania.
Yes, Your Honor.
Okay. Under section 528 of the BNSS 2023 for quashing and setting aside of the GR case number. Where have you mentioned GR case?
89 of
GR
06,
case
Your Honor.
number 89, 2016, 2006, arising out of the, which PS?
It appears, Your
It appears 86 of 2006, Your Lordship.
Out of the ITA PS case number 86. So 06. For the scanned copy of the trial court record, issue notice, sorry, just Miss Tijini, Lanet LPP. Since Miss Tijini, Lanet LPP accepted notice, no formal notice need to be issued to the state respondent, staff para. Please this matter
After 2 weeks, Your Lordship.
after 2 weeks. You see, you are unable to point out at what stage it is.
Your Honor,
Para.
interim may be granted. Your Honor.
In the meantime, in the meantime, the trial proceeding of the GR case number 89, 2006 before the Chief Judicial Magistrate UPSL remain state.
Much okay.
May I please, Lordship?
Yes,
Lordship, this is a FIR arising out of non-payment, non-refund of the loan amount entered between the petitioner and the complainant. Here in this case, 4 complainant. The page number 18 is the FIR. Out of these 4 complainants, all the complainants, they have, after filing of this FIR, they have filed money suit. And 2 informant money suit, they have already get a judgment. The judgment on admission in money suit. And the remaining 2 informant, the money suit is pending before the Learned Trial Court, SAPA. So my submission, my humble submission prayed before this humble court, this FIR is arising out of only completely civil in nature matter. No such incrimination for the offense 420 of IPC. And moreover, the money agreement was entered in the year 2019, and this FIR was filed on 2022. In the FIR itself, there is no such delay has been explained.
call for the record.
Yes, notice may be issued.
In the meantime,
Pardon, Mr.
T. Torum.
Land Council for the petitioner. Start. This is an application filed under section 528 of the BNSS 2023 for setting aside and quashing the criminal proceeding under GR case number 74, 2022, under section 210, 120B, 420 of the Indian Penal Code 1860. Horizon Auto SEPA PS case number 47/2022. Issue notice. Call for the scanned copy of the file code report is since Ms. Jenny P. Jenny Planet Edison PP has accepted notice on behalf of the state respondent, number one, no formal notice need be issued. Start. The petitioner shall take steps upon the respondents, the rest of the respondent by the registered post which AD within a week from today. Stop. List is matter after 5 weeks.
My lord, in the meantime, the proceeding of the learned court below may be stayed.
No, we do not know. There is a, you should clear an allegation. Can it be stated?
Your
What is
Lordship,
the allegation?
allegation is that they had taken
What-
loan amount, Your Lordship. However, the security that they have submitted was a loan allotment document, which was neither
What is
theirs.
the stage of the trial of this case?
Evidence stage,
Evidence.
prosecution evidence.
How many witnesses have already been recorded?
Complainant evidence has already examined.
Examined.
Yes. And on the official witness is yet to be examined.
Your Lordship can otherwise fix a very short week and let them take steps through the office of the public prosecutor in that case, even if the matter is not stayed, because it has already, the trial is already in the verge of completion, Your Lordship. In that case, Your Lordship may grant 2 weeks of time and let them take steps through the office of the PP, Your Lordship. Because otherwise also it's
Okay,
their duty
Then
to,
scan copy, then we'll fix early date.
yes,
Okay, just stay. Okay, then this is matter after 2 weeks.
yes.
Okay.
My lord, meantime, proceeding may be,
When the next date is fixed?
next date they fix on,
Let us
June.
see,
Yes.
because you say that the informant has already been examined. Let us
Yes.
see.
Yes, Your Lordship, if the date is given to that early, Your Lordship, they may
Then
take
when?
steps, and they may take steps through the office of the public prosecutor.
Then you take steps for the, okay, take steps upon the rest of the respondents by the register post with ID as well as by user process through the
Office of the public prosecutor.
public. Okay.
The,
all right.
Yeah.
Your Lordship, hearing Lordship, the respondent has not filed an affidavit in opposition in the main CRP case, Your Lordship. Even there is a IA regarding IA number 7 and IA number 8. They
Not
sought,
yet filed.
yes, they sought
When?
time to file reply, Your Lordship.
When can you file?
We need some more time to file everything.
You are Mr.
T. Darin. Lordship, further, they may be given a last chance to file this reply, Your Lordship.
E.
T. Darin, Your Lordship.
Land Council for the petition was present. Stop. Mr.
Sita Jo,
Hmm?
Sita Jo,
Sita Jo. Land Council for the respondent. How many respondents are there? You are for respondent number?
For this.
the sole respondent.
Appearing on behalf of the respondent. Pray so father, how much time you said?
Your Lordship, 2 weeks.
Father, 2 weeks time to file affidavit in opposition. Yes, sir.
Lordship, on last occasion, they sought time in filing reply in IA number 8, Your Lordship.
IA is for what?
IA number 8 is for amendment, Your Lordship. Amendment of the main suit, Your Lord. Main petition, Your Lordship. That there is certain paragraph that we prayed for amendment, Your Lordship.
Petition.
Yes, Lord.
Then you see, they will take time. Naturally, they will be giving you.
We have already filed, Your
Let's
Lordship.
amend.
We have already
Already
filed.
filed?
Yes, Your Lordship. They sought time to file a reply, Your Lordship, in that case.
The amended petition?
Yes, Your Lord.
So this was allowed?
Yes, that was
Which one? IA?
IA number 8, Your Lordship.
8.
Yes,
This was already allowed.
yes, yes, your lordship.
Why is it ordered?
Order, yes. That is not been allowed, your lordship, but they sought time to file and reply in that IA, your lordship.
In the IA also you are going to file objection. IA is for what you said?
That is for amendment of the,
Amendment.
yes, your lordship. And IA number 7 is for implement, your lordship,
It's
necessary.
not yet filed.
Yes, sir.
In the main also.
Yes, your lordship.
Then why it can't be allowed? What is the proposed amendment?
There was a certain thing that we missed out in the earlier CRP, your lordship. Therefore, we
Where?
paragraph, I forgot your
What
lordship.
is that certain mistake?
A certain paragraph that we needed to be implemented added
I'm
here in the
specifically asking you, what is that?
lordship. I am not having brief today, your lordship. I am appearing on behalf of BPHI.
In that case, I think once they file affidavit in the mail,
Yes,
and probably they will object it.
yes, your lordship.
You should come ready, actually. Come prepared. What is this? Another IFO?
That is IA number 7 is for implement necessary parties, your lordship.
You don't have a brief,
No, your lordship.
not yet implemented.
That is not been informed, your lordship. Not been instructed.
Improvement can be done, but we are not prepared. Okay, yes. Please sit after. The prayer is allowed. Please sit after 2 weeks. Okay.
Obvious.
Oblige, your lordship.
May I please, Lordship?
Hmm.
Lordship, here in this
Just
case,
a minute, just a minute, Let me see just implement. I think he's creating some confusion. Just a minute, Just a minute, Please. Hello, who is for the respondent? Just a minute, One minute. You have an objection for implement of the party. Do you think that they are the necessary parties?
Your Lordship, I am not aware of this case.
Okay. Then it problem. Becomes okay. See, come prepare, implement. If they are a necessary party, if you can just satisfy, it can be implemented only, so that in the meantime you can take notice, you take steps upon them. Okay, anyway. Item. This is 7. 7 and 8. Yes.
may I please, Lordship? Lordship, as per the last order, that is 8/5/2025, this honorable court has directed the petitioner to deposit rupees 30 lakhs
Okay.
within the 10 days from the date of order, that is from 8/5/2025. Lordship, accordingly, we have deposited 30 lakhs and we have filed an affidavit to that effect, Lordship. I have filed an affidavit on dated 20th of May 2025. Additional affidavit.
So you have received.
Yes, sir.
Lordship, your lordship passed an order
Ah.
for the directly 2 crores.
There is,
Then-
there is.
Then down to 30 lakhs.
During the last hearing, they said we will be, it's not the court direction of direction of the court.
Ah.
It was their proposal that we will instead
it
of
was
2
on the
crore,
proposal.
30 lakhs we will deposit.
Total was 20 crore. How?
16 crores.
16 crore.
Yes.
Lordship.
Now, my lord, you.
And actually the.
It was
60
your
crore-
lordship's order earlier that
The,
1 crore each should be deposited in each of the case.
but then thereafter it appears that it has
And
come down.
the second time, they didn't deposit that one, they said we will deposit in 30 lakhs. So, of course, this honorable court said, my lord,
To deposit
after-
30 lakhs.
it will look into the matter and give time accordingly.
Hmm.
Now here they have sought 6 months, that I don't think we have, from my side, there won't be consent for that one.
See. Suppose you are representing the state cooperative,
Yes, Apex Bank.
represent the managing director.
Yes.
Who has the power to grant loan? It's approval of the managing director.
Yes, yes.
Okay, and the branch manager used to grant.
No, branch manager proposes the loan. It goes to the head office and
Okay.
there's a committee for that granting.
Okay.
Committee, they-
Committee should suffer then,
no, well,
knowing that he has no capacity
no,
and then the security,
no,
mortgage property is also not enough.
no, Lordship, what happened, and then both of us went to Lok Adalat. There was a mutual decree that he will be paying this in installment within a very short period, 6 months. It is a decree, your consent decree.
Mhm.
So when they didn't fulfill that one, we filed for execution. And execution, of course, the direction was to send him to jail. Against that, they have approached this honor. Now, this honorable court definitely says that you want money, why should person should be sent to jail? Because after all, our interest is to get the money back.
Money, not,
Yeah.
not the person to be convicted, or sent to jail.
Of course, the ultimate option is coercive.
Yeah.
Lordship.
Now, ultimately,
If a sitting MLA is sent to jail, definitely they might try to manage the amount. That also. Ultimately, Lordship has to.
See, in the money decree, execution has a limited power, execution power. And even,
Ultimately, your lordship has to see whether the revision petition is maintainable or not. That ultimately that decision has to be taken.
Hmm.
Till date, we are not arguing the merit of the revision
not
petition.
not yet.
Yes.
Yes.
So,
And probably this, in the last occasion, this last order, consider for further extension of the time. So now, what next then?
let him explain how he is going to pay the amount.
So the original order, original is of course 16 crore.
Yes. They have deposited
Now-
1 crore.
Now,
Malan.
in order to show the bona fide, you, on your proposal, you were asked to deposit 2 crore, and then you again came down to 30 lakhs. Now you see, this 2 crore still stands. So this probably, so how you are going to do about it? Otherwise, you see, lordship. And his writing has pointed out that whether the revision lies. And in that case, if this court made such an observation, it will be very, very difficult for you. And now it's you who is to decide in order to show bona fide, in order to survive for the time being. So what do you want?
Yes.
You want the matter to be disposed of?
No, Lordship, I seek some more time, Lordship. Lordship, yes, because Lordship, during the time of obtaining the said loan, I have mortgaged my landed.
No, that you see,
Lordship,
all gone. The decree is
not-
against you.
Lordship, I have filed.
Now we are in the stage of the execution, the final stage for sending you to jail.
Lordship, I have filed an affidavit to the effect that the said land is under
We do not know that, you see, that cannot be the ground.
Lordship, by selling
cannot.
that property, I am repaying the money.
Oh, you are standing, you see, present,
Yes.
you are MLA, MLA.
Yes, yes.
I see, and that, you see, that cannot be the ground.
And Lordship, here is a 15,000.
And then you are
Square
trying to
meter
show that that is the only property that you have at the moment, being a sitting MLA. That cannot be. But
Lordship,
then you see, the bank is going to, I think the bank has some problem nowadays.
Yes, of course.
Because of all this. And then who are the ultimate sufferer? The public. And then the court also will not be, of course, too much of liberal to that extent. Under the circumstances, knowing that banks are suffering, banks are unable to give proper service to the public because of the people like you. That will be difficult.
Lordship, the mortgage led already, it has been developed, and we have already made a plot system. And now the prospects buyer.
That cannot be the target. At the time of, you see, it was on
2019.
2019.
6 years now.
On a good faith, you were, on a good faith, probably you were given loan and you have to now, it's your duty to pay back.
You are to show our bona fide, we are repaying the amount. So far, we have paid rupees 1 crore 30 lakhs to the bank. And we
Now
are
this,
clear-
the 2 crore was passed on 22/5.
Yes.
25 to, oh. Now what is your proposal?
Lordship, now the said plot of land located at Jolan Julie.
Forget about that.
Yes.
Forget
Lordship,
about that.
It is the only.
That is
source-
your, you see, that is your lookout,
Lord-
whether you dispose it of or not, no?
But Lordship, my target, my proposal is that by disposing or selling that said proposed sale land, we will repay back the decretal amount. in the long run.
And then if,
We need some more time. Lordship, in an
and
installment.
then if,
basis-
if you are unable to dispose of that, yeah, that means you are not going to pay.
No, Lordship, we will pay.
Then
We'll
I
pay.
think we have to pass an order only.
Yes, Lordship, but some more time maybe.
No, we have to dispose of this revision petition itself in that, case, if that is your proposal.
Lordship, I prayed it some more time maybe. To deposit the money partly, not in one go, Lordship.
No, we cannot,
In one go, Lordship, it may not be possible.
we cannot. Whether this court has a power to direct, to pay, make a part payment when the execution petition is
No,
pending.
one of all these payments, your lordship direction was
This is
only
only,
to ask him to show bona fide
Show
that he
bona
will
fide.
go.
that
quit.
was the only, that was the only idea
Yes.
Lordship, petitioner,
that you were giving some time at least.
Lordship, petitioner is genuinely serious to deposit or repay back the said, above said amount of money. But at least some more time may be given. So that he may be repay the amount partly also. Because by putting the petitioner inside the civil prison also, Lordship, the purpose of the respondent may not suffice. We are making very serious endeavor to sell the land.
Or Mr. Ketutaba, land council for that.
Within 2 months, we'll pay another
Petitioner.
30 lakhs.
Also had Mr. Peter, land council for the respondent number 1 and 2.
Yes.
Mr. Mr. Peter, land council for the petition, some mistakes. Is undertaken by the petitioner. The petitioner has deposited. It's a deposition or what?
Yes, sir. Lordship.
Deposited
Yes, 30 lakhs
an amount of rupees 30 lakhs.
on 13/5/20.
was the repayment of the repayment against the loan account. No, no, against is loan account number 190000069950, maintained in Arunachal Pradesh State Cooperative FX Bank branch, code 102, on 4/5/2024. Since the petitioner has deposited the above amount in order to show his bona fide that he is ready to repay the entire amount, the petitioner, the learned counsel for the petitioner, prays for further time to satisfy the loan amount. Learned counsel for the petitioner submits that since now the mortgage property is under the process is a process for disposing.
Yes, Lord, sir.
For disposing.
Plotting has already been completed.
Okay. By in the process for disposing, stroke selling the mortgage property to the prospective purchaser by publishing advertisement in the newspaper, local newspaper. He prays for granting further time. So, for further time for certain further time for further time for repayment of the loan amount. Mr. Itapo, not a counsel for the respondent, please. Serious objection. Stating that the stating that the disposal or selling of the mortgage properties cannot be the ground for extension for the time, extension of the time. Okay, so be that as it may, stop since the petitioner has petitioner by depositing the amount of rupees 30 lakhs on
13/5/25.
8/5,
13/5/20.
13/5.
We have
not 4/5.
Oh, sorry, Lord, sir, within 2 months.
Deposit on 4/5/2024. And has undertaken to repay the amount within a reasonable time. The petitioner is granted further how much time?
So I'm present at least 2 months time.
No, no, my lord, you look
For
in,
posting 30 more legs.
in February,
No,
Lord,
no, 30, not 30. These two-
in February, your lordship granted, your lordship passed the order in February.
Yes.
March, April, this is May, 3 months. That was 2 crores, so 1 crore each. At least that amount should
Granted
be
for the two,
1 month maybe for depositing some amount, not 2 months,
2 crore.
1 month. Already in February, your lordship granted time.
Father, okay. 6 weeks, we'll say 6 weeks, in between, 6 weeks time to deposit, the rest of deposit. The rest of the amount is directed by this court from 25 to 2025. This is matter after.
My lord, we specify 1 crore 70 lakhs.
Okay.
Otherwise,
Okay, the order is that, no?
you know, my lord,
22 is that order only?
yes, my lord.
Okay.
If amount is specified, then my lord, it will be,
That-
because 30, the minus
that-
30,
that
it will
is-
be.
That is rupees 1,70,000 crore. Okay.
1 crore 70
1 crore 70
lakhs.
sorry. 1 crore 70 lakhs. This is matter after 6 weeks.
Next one is link case, my lord.
Link case. Okay.
Lordship, the service upon respondent number 5 and 7 are still awaited.
No one appears on behalf of the petitioner on call, so the office no dated 22/5/2025. The service in respect of service report in respect of respondent number 5 and 7 it is still awaited. In view of the above, let this matter be listed after 3 weeks. So, if Ms. Eugenie Lana additional PP is present. Okay.
Keep it.
On behalf of the state, huh?
Yeah, Lordship.
Yes.
Lordship, this petition was filed for the passing of the FIR. But in the meantime, the charge has been filed.
In the meantime, charge is filed.
Lordship, kindly I beg your Lordship, file an additional affidavit to bring it into record.
Okay. Mr. D. Sultan, Lana Council for the petitioner, some steps. During the pendency of this petition, the IO of the case has already submitted the case into charge sheet. Therefore, he may be allowed to. Therefore, praise that we praise that. Therefore, submits that he may be allowed to file additional affidavit. Additional affidavit for what?
For bringing the charge into record.
In the meantime, we call for the case record then, in that case, trial court record.
Yes, yes, if it is charged,
Okay.
then easier.
Okay, since the case has already been submitted in charge sheet, let the trial court record be called for. Okay, list this matter after 2 weeks. Okay.
Obliged, Lordship.
Your Lordship, item number 10, the council is here.
Your
Item number
Lordship,
10.
I'm for item number 10. I'm for the petitioner. There is the interim order that may be continued.
Okay, in the 10. Then, in that case, Ms. Rai, planning council for the petitioner is present. Or Ms. Jeannie, planning additional PP is present. And the office not reflect, okay? Then it's up after 3 weeks, no? Then interim continue, okay? The interim order pass are there, we shall continue, okay? Yes.
May I, Lordship?
Yes.
Lordship, as per office note 25,
Yes.
2025, Lordship, service
Service
report,
report,
still awaited, Lordship.
when you have taken steps, when did you take?
Lordship, I,
Probably you have taken step long back.
Yes, Lordship, it's a
Then I think
24.
in that case, what is this case for?
Lordship, it's for,
Probably you may have to take further steps upon the respondent. You have taken a step much earlier. It was way back in the February. No.
Lordship,
When did you take,
Lordship, I cannot able to recall, Lordship, it's into.
long back?
Lordship, Lordship.
So I think you have to take a step, press a step. Okay, in view of the office note dated 22/5/2025, Mr.
Okay, Lord.
Okay, Lord, planning counsel for the petitioner prays for allowing him to take press steps upon the respondent. He's a sole respondent.
Lordship.
That's why the prayer allowed. Okay. The steps upon the respondent be taken by a registered post which AD as well as by usual process within a week from today. So at least it's matter after 3 weeks.
Lordship, there is an interim order.
The interim order passed earlier shall continue till the next date of this thing. Okay.
Right.
Your Lordship, here in this case, service is still awaited in respect of respondent number 126.
When did you take steps?
Last time I took on March 24.
March.
Yes,
Now see April, May,
it's been.
almost June. I think you have to take press steps.
Lordship, it may be listed after a week, and last time, this time I will try to check the status, and in the next occasion it may be given one more opportunity for steps.
Mr. Kambo, what
Yes.
Kambo?
M. Kambo.
N.
M. Kambo. Yes.
Counsel for the petitioner is present. So the office note dated 22/5/2025 reflects that the service upon the respondent number 1 to 6 is still awaited. And you are about let the matter be listed after a week.
Yes, after a week.
Oh.
Lordship, there is an interim order.
After
Yes.
the interim order passed earlier, shall continue to the next date.
Much obliged.
Yes.
Well, criminal petition for setting aside of the criminal law. First of all, matrix,
Item
arising
14.
out of this motor accident.
Okay, that's fine. But then whether notice was issued to the respondent?
No private respondent is the party is already.
No private respondent?
It's joint
private
petition.
respondent, Because,
It's a joint petition.
because this is a settlement also, complainant himself is the accused in the case. Complainant himself is the accused in the case.
How?
Because it is a motor driver, as per the investigation report,
Huh.
he was a learner. Informant is a learner, he was driving on the car at the time of Itanagar RK mission, nearby RK mission. In the intersection side, there was a 3 boys was running triple carry and hit over the car, and he filed FIR. According to the course of investigation, it has been said that it is not the boy, but it is you. You have entered in you have entered in the wrong road. That is
Okay.
because of which accident has caused. That is the
Okay.
accident.
So you made a struggle.
Yes, all of the parties and in terms of the compromise
What
agreement.
the record says? Anything?
Record lordship, they had to call for the appearance lordship in the record.
Appearance.
Yes, lordship.
The offense is 279. Which one is not, which one is not non-comparable?
279
Two
lordship.
79 is non-componable and 338 is also non-componable. I have verified that.
Okay. So since the informant himself is the accused.
Yes.
And then since they have agreed, where is the agreement? Agreement, have you? annexed?
Agreement is noted. Guidance is page number.
Okay,
38 onward.
Yes, 38, 39. 38 is annex of 3.
okay, I'll take the basic. Third, Mr. T. Tapa, planning counsel for the petitioner. I've also heard Mr. Hage, land additional people. Staff, para. This is a joint petition, right, filed by
All the issues.
four persons. Under section 528 of BNSS 2023 for quashing and setting aside the FIR dated 3/5/2020. No. It has already charge sheeted, you said? Okay.
Yeah,
Of,
no,
okay, quashing and setting aside of the GR case number 293/2023 arisen out of the Itanagar PS case number 96/2023 under section 279, 337, 338, 427 IPC. Which one is the informant?
Informant is the number one.
One.
Gaporonya.
Gepo. And then 2, 3, and 4 are according to them, according to him.
Yeah.
He is the accused. But then let us see the charge sheet because this fact is to be recorded. The petitioner number 1 is the informant. Petitioner number 1, Sri Gepo Ronya, is the petitioner, is the informant.
Informant become accused.
Stop. The petitioner number 2, Sri Choki Talum, comma. No, just me. Okay, the petition number 3, Sri Kyoda Tarak, and the petitioner number 4, Sri Rahat Talar, are the alleged accused in Itanagar, in GR case number 293/2023, arisen out of Itanagar PS case number 96. No, don't write GR case here then. Alleged accused in Itanagar PS case number 96/2023 under section 279, 137, 338, 427 IPC. Stop. Para. The case of the petitioner's case is that on which date?
But it was
On 3/5/2023, the petitioner number 1 lodged a written FIR before the officer in charge, Itanagar Police Station, whether the petitioner number 2, 3, 4, their name has been mentioned in the FIR.
yes, in the mention last second last paragraph. Choki Talum Koda Tarak and Rahat Talar.
Okay.
They have received injury out of accident.
Stating there that on 3/5/2023 at around 6:30 a.m. when while he was coming from RK Mission Hospital site, at Fry Junction. At Fry Junction, juncture, stroke Tinale, near Clock Tower at Ganga Market. All of a sudden, these three persons were in one bike.
Yes, three
Okay.
persons were in the one bike.
Okay,
They're having triple KT.
the motorcycle bearing registration number AR01 and 4873 approaching towards his car in high speed. With triple carry by high speed. Where did it hit his car? Where do we find?
Actually, yes, that the
High speed in the reckless mode of driving is traffic area that do without putting in unless full conscious and
actually bike strike over the car, but the
where do we find that?
kindly see the FIR. I read the FIR. In the FIR, this it was a car was newly bought car. It was
No,
morning.
where do we find that it was
Kindly see.
page?
Page number 20.
No, line, which line? 3% of line.
In the morning 6:30 a.m. I was coming from arbitration site, hospital site, and in the moment I was about to take my right turn from
Collided, huh?
Yes, collided.
Collided
Yes,
with his I-10 car,
I-10 car.
causing cause damage to your
Yes.
vehicle, causing damage to his
Both the
vehicle.
vehicle damage.
The motorcycle was ridden by three persons named namely Chuki Talo, Choda Tarak, those three persons, huh? And Rata. That in that serial, in that sequence, you just write the name in that sequence. Petition number 2, 3, and 4. Okay. They are, Chuki Talo, Choda Tarak, and Rata. Para. Just continue. Based on the above written FIR, the police has registered the case being the aforesaid case being Itanagar PS case number 96, 2023, under section 279, 337, 338, 427 IPC. And investigated into para. Upon completion of investigation, Then the above line above investigated, that bring it down, next paragraph. During the course, and the case was investigated into, during the course of investigation, the IU found that found from the CCTV footage of the accident where it was found that the informant, petitioner number one, and the I-10 car bearing AF applied for AF belong to the informant, petitioner number one, negligently driving, no, AF, bearing AF, negligently driven by the informant, hit the riders of the motorcycle, Yamaha FJ bearing AR 01 and 4872. So accordingly, upon completion of the investigation, case was submitted, case was laid into charges against the accused, against the informant petitioner number one for offense under section 279, 336, 338, 211 IPC. What is this 128, 129?
129, this is
Under this section also?
yes,
MBW, this motor vehicle act also, 120, 129.
And also under
motor vehicle,
and also under
motor vehicle.
section 128, 129 of MBA. Can you see what is this?
This is penalty.
Okay, MV Act 1988. So, no, leave that, probably. And no, Choki Talum is also found.
Lordship,
Committed
128,
some offense, yes.
Lordship, 128 MPA
Okay.
is regarding the
Against the petition number one, semicolon. Under section. Geporonya also.
Not Gaporoja is the car driver and 128.
Oh, sorry.
MBA.
Okay. Under section 128, so 129 MB Act 1988 against. Choki Talum is petition number
2.
against
Choki Talum is 2.
Sri Choki Talum petition number 2. And again, Kyota Tarak also?
Yes.
Okay, semicolon. Under section 129 MBX 1988 against accused Kyota Tarak.
And one more.
Accused petitioner number, against Kyota Tarak, accused petitioner number 3. And under section 129 MB
Against Raha
Act 1988 against accused petitioner number 4 Raha Talar. That means all the four
That
are
is the
accused
whole-
persons.
That is the party involved in the accident.
Ah,
Actually, as per investigation, the result was otherwise. Because petitioner number one, Mr. Gaporaj was
Hmm.
learner at that point of time.
Okay, so,
He was having new car.
okay. Then, Tara, on receipt of the charge sheet, the learned chief judicial magistrate has taken cognizance of the case. So, trial started, begun?
Well, not yet started.
Okay,
charge sheet has been filed.
process issued.
Yes, not process, already filed and charge sheet already filed. And process is yet to be started, I think. It is pending in the CGM court.
And the same is pending,
Process is yet to be started.
okay, trial before the court of the chief judicial magistrate. UPR, start. The learned counsel for the petitioner submits that, however, during the pendency of the trial and the pendency of the, when this was, agreement was entered, okay, the pendency of the trial, the, all the accused petitioners have compromised, have settled, amicably settled the matter amongst them and executed deed of settlement compromise on 17
March.
March
March
17/3/2025. Start. The compromise deed contains that the parties have amicably settled their differences with the initiation of the responsible elders of all the parties in order to maintain peace and brotherhood among the parties. Start. The parties have agreed that the accident occurred not due to intent, so due to just a minute. Not due to the no, accident occurred unintentionally due to negligence on the part of the parties due to the negligence of the informant, petitioner number one, and therefore the petitioner number one would bear the medical checkup expenses of the other accused petitioners. And since the matter has already been compromised and mutually settled between the parties, none of the petitioner or accused petitioners. Okay, the parties doesn't have any further grievances against each other. And therefore, the parties expressed that none of them would like to pursue with the matter any further before the court. And they have also expressed that they wish to withdraw the case against each other. Then the rest is there any material here?
Lordship, here, Lordship, there are only appearance before the Lordship, court Lordship. Charge sheeted, Lordship, that for the CC stage, Lordship.
The
And-
the Rana Council for the petitioner submits that since the parties have mutually settled the matter, however, the case, however, since the case has already been charge sheeted and pending trial before the court of the court of the Chief Judicial Magistrate, the Chief Judicial Magistrate doesn't have the power to compound the however, since the offense alleged against the accused involves with non-compoundable set offense, therefore, therefore the petitioners have filed petitioner by filing this petition under section 528 approach this court as the court of the Chief Judicial Magistrate doesn't have the power to compound the non-compoundable offense. Okay. Then the rest.
If the chances of punishment is blinked, then it can be lost.
Hmm?
Because as the both the parties have severed mutually lost, the chances of conviction is blink, Lordship. So chances of conviction is blink, Lordship.
Yes.
Yes, Lordship.
There is no, because both the parties,
Yes,
all of
Lordship.
them are accused.
Yes, Lordship.
Now they will be giving evidence against each other.
Yes,
So
Lordship.
since they have expressed that they don't want
Yes,
to
Lordship.
pursue the matter, that means they will not give any evidence against each other.
Yes, Lordship.
So there is no chance for condition.
And they have
any of the
compensated each other,
any of the
Lordship.
accused
Yes,
persons.
yes,
So under
Lordship.
the circumstances, it will be an futile exercise.
Yes, Lordship.
Therefore, it will be to set aside and class. Okay.
Yes,
Yes. Okay, this is general. Rest disposed. Yes.
Yeah, Lordship, we have received the case diary, Lordship. But the other party it seems to be absent today.
15.
Yes, Lordship.
No one appears on behalf of the petitioner on call.
Then I may be directed to retain the case diary, Lordship, because we have
Well,
received the case diary.
However, Ms. Nhabi, Lana Council, Lana additional PP. Yes, there is it was a case diary?
Yes, Lordship.
Case diary or case record?
Case diary, Lordship,
Okay.
because it's a quashing of the FIR.
Ms. L. Hajan, additional people is present with the scan copy of the case diary. The scan copy?
Yes,
It-
Lordship. Scan copy.
Case diary. And since the party is not
Uh,
present.
sorry, Lordship, this is the Lordship, is
She
it
may-
original Lordship?
She may be, original?
Oh, yes, Lordship,
Okay.
then it may be sent back and
It's
Lordship.
the
updated.
case diary of the original case diary of the case, and therefore praise that the case diary may be praise that the case diary may be returned
Yes, Lordship.
with no stop. List this matter
After 2 weeks, Lordship,
after 2 weeks on which date
updated
the-
case diary.
on which date the additional PP shall produce the updated case diary. Okay. Updated scan
Scan copy,
scan
Lordship.
copy of the case diary. Okay.
Apply.
Yeah, Your Lordship.
Yes.
Your Lordship, this is a joint petition, discriminatory petition paying for the compounding of non-compounded offense registered against the minor accused person for the quashing and setting aside of the FIR dated 3/30/03/25. Registered being at Ita Woman PS case number 11/25 under section 77/79 of BNS. Your Lordship, on the last date, it was called for the scan copy of CD. Though the scan copy of the CD has not been received yet, has my senior conducting counsel for this matter, K. Lolling, is out of the station. So kindly, matter may be fixed after 1 week for the admission hearing.
This is also joint petition.
No, Lordship, this is on the merit, Lordship.
No, this merit.
Yes, Lordship, item number
There is
16.
no, there are two petitioners
Yes,
and
Lordship.
against the state only. What
Item,
is this case about? Discrimination.
no, item was 16, Lordship.
Item 16.
Yes, Lordship.
It's a 15 only.
16 is not stay, Lordship.
What is this petition for? It's a quashing petition.
Yes,
Yes, Lordship.
There are two applicants. Two
Oh, yes,
petitioners.
Lordship, they have some. Oh, yes, Lordship, they have come for the. It's also a joint petition, Lordship, but we have received the case diary.
Yes, sir.
Yes, Lordship.
Original or scan?
Lordship.
Original or scan?
Yeah, this one, Lordship, this is original, Lordship,
Original.
with the pen drive also. This is in the, but Lordship, sections are serious in nature.
Serious.
Yes, Lordship.
The case is serious.
Yes, Lordship, sections are serious. Even the investigation officer has prayed for the not to quash the proceeding, this one, Lordship, investigation process.
The parties are major.
Lordship. Accused is minor, Lordship.
Accused is minor.
Yes, Lordship. Victim is major.
So what to do? What is your prayer, you said?
Has
Next
my
week,
s- Yes, after, this is after 1 week.
after 1 week.
Yes, actually.
Who will argue the matter?
Kim Lawrence, my senior.
Okay. Then let, senior be present.
Yes, Lordship.
Miss
M. Soran.
M. Sora. I missed that. The conducting council, Mr. K. Lole. He is out of the state, we therefore pray for action and the matter for every staff. Yes, well, have you? This is original.
Yes, Lordship, original.
He is present with the original case diary. Please pray for comma, list this matter after the staff. Then wait the case diary to be produced after a review. To be produced a scanned copy of the case
Updated case
diary
diary.
after a week. Okay.
Updated case diary, Lordship, because it.
Updated scanned copy of the updated case diary of the new case diary on the next stage.
Yes, yes.
Of license.
Much of license.
Not yet. Unlisted, not ready.
Unlisted today we have made a mention and it's not allowed. And file is under process. So it's not
There is only one.
two, Your Honor. Yes, Your Honor. It has been endorsed to court number 2.
Then in that case, it will be it will be listed on Monday only.
Your Honor, there's an urgency, Your Honor, in civil revision petition, Your Honor.
Bring now.
It's requiring only 20 minutes.
Kindly, Your Honor.
Okay, then when it is ready, we'll sit for. Okay, then at 2, then.
Deeply
At 2.
my lord. When this fact brought to the notice, my lord, they made the complaint to the authority, and authority, my lord, under the chairman of circle officer, my lord, all stakeholder of Tarak Landi, they were the joint meeting on 25 August 2023, my lord. We will see at page 46, my lord. That's starting, my lord. Page 20, it's a minor meeting conducted under the chairmanship of the circle officer Tarak Landi, my lord. My lord, wherein all the clan member represented, my lord. The one of clan member, my lord, Taring Bat, who was a ZPM Tarak Landi, my lord. Taring Bat, my lord. Now, page 46, my lord. My lord, even the ZPM, who is the representative of Taring clan, they also clearly admit, my lord, second para of his version, my lord. Taring Bat, second paragraph, my lord. He mentioned that during the period of show, Lada, Laji, Shonsor, PW, Shonsor, restarting to the Nama used to headquarter lands. However, after discussion of land, Shonsor, Malad, second last page, Malad, it was decided that first priority should be given to the land owner, namely Dora and Richie clan. They also admitted this land, the genuine land owner is the Richie and Dora, Malad. Now, after having heard this old fact, my lord, now the question arises, how come this Taring clan, who was not landowner and their name has been enlisted in the list of landowner, my lord. So after taking this aspect, my lord, page 48, my lord, final resolution was passed by the, passed in the meeting, my lord. Page 48, last, my lord. At the end, discussion, at the end of the discussion, the House unanimously agreed on the following resolution and agenda to be taken up in the subsequent meeting. A, land demarcation matter will be taken up after election, 2024 election. The matter pertaining to entry of Taring clan in the name in the land donor list would be decided in the final agreement arrived upon the succeeding meeting. Now, this is the consequences of outcome of pursuant to this, the minute decision, the circle officer requested the head GB at page 49, pursuant to this decision, requested the head GB to constitute a customary court, interblazed customary court, to decide, to settle as to how the Taring clan has been enlisted in the donor list, where he's not, Taring clan is not a landowner. This was this is the genesis how the impugn order has been passed. Now, as per this order, page 49, dated 20 November 2024, settlement land ownership dispute. Now, you are requested to form interblaze customary court and settle the matter of entry of Taring clan name in the donor list of the Tarak Landi headquarters as per minute so. My lord, based on this, my lord, page 50, my lord, the CO's request was to constitute an interblaze customary court, that is various congregation of the blaze authority, Gamburas, not a PR. Now here, my lord, see, pursuant to this order, my lord, this order has been issued, my lord, appointing himself. And also another point we have asked, we raised, my lord, here, Takubeli head GB, he himself is the relatives of the family, close relatives of the Taring clan and father-in-law of the respondent number 1, my lord. We have raised this point also. Now, pursuant to this, my lord, the subsequent on 4th March, my lord, as there was a disagreement with regard to the constitution, the meeting Keva was held, and during the pendency, my lord, at page 64,
Keva was held.
Keva yet has not yet held. As per this page 50, my lord, it was supposed to be held on 4th March, but that was not held. So, subsequently, during the pendency, my lord, during the pendency of this Keva proceeding, at page 64, Taring youth clan, page 64, the issue of circulation forcefully demarcating erecting the pillar, declaring themselves as a landowner, which is not fact, my lord, when the matter is that is how they have entered into the name list of the donor. That is to be decided by the Keba, my lord. During this pendency, my lord, this circular is issued by the Taring Welfare Society, my lord, Youth Welfare Society at Taraklendi. Against this, my lord, having found that there's likely the breach of peace and tranquility, my lord, show Taraklendi has issued a prohibitory order at page 73, my lord. Page 73, my lord. Prohibited them carrying out such illegal activities, my lord. Page 73, my lord. Now, my lord, thereafter, my lord, we have made a serious objection, and despite of this, my lord, at page 74, second mail order, my lord, was issued by the same, my lord. And arbitrator, he is the same, my lord. 74, my lord. Against this also at page 74, again this mail order, impugn order, that is scheduled to be held on 27th of May, my lord, on Tuesday, my lord. We have submitted a written objection also at page 75 on 20 May 2025. The recall citing that PI cannot be a judge of the Keba proceeding as he's not a blaze authority, as he's a government employee, and furthermore, the head GB, he being the relatives of the,
Where have you said that he is relative and he cannot?
my lord, my lord, in para 7, my lord, it's pertinent. Taring Baki Bosco is your son-in-law. It's addressed to head GB. Not only that, you have multiple material relationship with the Taring clan, and by virtue of such relation, you are abusing your power and position, which is against the statute. So,
Where have you said that the PI is not the
PI, my lord, it's the 8th, my lord.
Hmm?
8, para 8, my lord. That being the position, you are interested party in the instant subject matter and cannot be judge of your own cause. Moreover, Yin Taring is a political interpreter, a government employee, cannot act as arbitrator in this case, as it is prohibited by law. Now, in this same line, my lord, I'll just straight away, I'll just rely the division bench of our High Court, my lord. There are series of decision, my lord, relying on division. On the same, strictly straight away on the point, madam, involving the political interpreter as a judge in a Keba proceeding, it vitiates, madam. Paragraph 10, madam. Similarly, madam, here by involvement of PI, madam, decision was taken, it was put to challenge, and ultimately, madam, this is the paragraph 10, madam. A bare reading of section 5 of the regulation clearly shows that this provision of regulation relates to the Deputy Commissioner's power to constitute a place authority. Section 5, subsection 2, authorities the Deputy Commissioner to exercise the power and function of place authority.
Where are you reading?
At para 10, my lord.
Para 10.
Yes, GLT 2009 for GLT. Para 10. May I read, ma'am?
Yes.
Bare reading of section 5 of the regulation clearly shows.
Para 10.
Yes, ma'am. I've marked also.
No, this is para 12.
Para 10, my lord.
No, it is para 12. Within para 12.
Sorry, my lord. Extremely sorry. It is a subsequent order, my lord. Para, it's a division bench. I have given wrong, not wrong, my lord. It's subsequent coordinate bench of 2022 on same principle, my lord. Para 10, my lord. It's a division bench, my lord. GLT 42.
GLT.
10, my lord. Bare reading of section 5 of the regulation clearly shows that this provision of regulation relates to Deputy Commissioner power to constitute a place authority. Section 5, subsection 2, authorities authorize the Deputy Commissioner to exercise the power and function of place authority either by himself or through the Assistant Commissioner under certain circumstances. In no way, Section 5 of the regulation authorizes the Deputy Commissioner to empower a political interpreter to intervene or fairness preside over or supervise the Cabinet proceeding. The duties of interpreter laid down under memo number shown, under data shown, and also do not confer any supervisory power on them. As a whole, the political interpreter roles in the judicial proceeding conduct of the Blaze Authority is limited to assist such political parties to come to a just decision. The limited role of PAPI has been reiterated in the letter dated so issued by the General Administrative Department of the State of Arunachal Pradesh, which has been referred to and relied upon by the learned single judge. In our considered opinion, our word assist itself denotes giving view of the administration only when sought for by the Blaze Authority. Certainly, it does not confer any supervisory role in the decision-making process. We are also of the view that if PAPI are allowed to supervise the KEBA proceeding as a government nominee, it would certainly influence the proceeding, wherein the dispute are resolved as per local custom, and it would amount to eroding, diluting the independent character of KEBA. This cannot be permitted under existing law and the scheme of the decision through KEBA. And similar matter, this coordinate bench, this division bench, coordinate bench in 2022 for GLT, relying this division bench, para 13, 14, in view of the clear enunciation by law by division bench of this court, impugn order dated so whereby both political parties were asked to supervise the KEBA proceeding is bad in law. Accordingly, impugn order are interfered with. It is further appears that decision of the KEBA dated so that said political interpreter were party in rendering decision, which is completely outside purview of the political interpreter, inasmuch as duty of the political interpreter is only to assist the decision-making process by giving their views on administration when sought for by the Blaze Authority. Judgment of division bench of this court had clearly stated that the role of the political interpreter, the said decision was rendered on so. In spite of said decision, the holding the field, the direction to hold the KEBA under supervision of political interpreter and also the political interpreter being part of decision-making process are a violation of the dictum of division bench of this court in Tadek Tabang, just now at the light. Now, this is similarly situated in our case, madam. Now, by this impugn order,
issue notice.
Notice, in the meantime, since the proposed illegal KEBA is proposed to be held on 27, it may be statement in interim until returnable judgment.
Pardon, Mr. Titagon. Mr. Titagon, counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, Railway Section 115 of the Code of Civil Procedure 1908, the petitioner received the mail order dated 24/2/2025.
Yes, my lord.
And extension of mail order dated 9/5/2025.
Yes, ma'am.
Issued by the head Gambura,
Nama village.
Nama village, Tarak Lengdi circle,
Karadari district.
from district Kradari. By where is the 24th page, 24/2/2025?
My lord, page 50, my lord.
By order dated
24 paper.
24/2/2025. the who is this respondent number
6, madam.
6?
Yang Taring has been appointed the arbitrator.
No, Taku Bell is
Madam Taku Beli is not, because he is
Okay.
the court, that's why we.
the head GB of Nama village appointed one Taku Bell head GB. Okay, himself, he himself.
He himself appointed
Oh.
the supervisor and Ying Taring PI as arbitrator.
Himself appointed. Sorry, the Taku Bell head GB of Nama village as himself appointed as head GB Nama with as supervisor. And one Sri Yend Tiring PI has been appointed as arbitrator. And where is the other impugn order? 95.
95 is at page 74, man.
By this order.
By this way, it is rescheduled to be held on 27 May
And by
2000.
order dated 9/5/2025, the mail has been fixed. Mail has been scheduled for 27/5/2025. Rescheduled, rescheduled.
Yes, rescheduled.
For 27/5/2025. Stop. The land council for a petition or submission. The head GB, what was his name?
Taku
Bell.
Bell.
He is the interested party in the instant case, being who he is,
Family relatives of Taring clan.
being family relatives of
Taring clan, and he is the father-in-law of
Taring
respondent number 6. Respondent number 1.
clan. Taring clan. Taring clan is the opposite.
Yes, opposite
respondent party.
Yes, sir.
Of the Taring clan within bracket respondent parties. And as such, he cannot be a judge of his own cause. What is the provision that prevent the judge?
My lord,
You have the copy of that.
my lord, there's a maxim, my lord.
Not maximum, but then in the provision itself, the Arunachal Pradesh Civil Code Act itself, it is provided.
My
that
lord.
He cannot become the judge, the interested party.
Yes, it is.
That's the provision. Do you have the copy of Civil Code Act?
Yes, Civil Court Act.
Judge of the own cause under the appointment of the Where is the appointment?
Section 17.
Hmm?
Section 17 of AP Civil Court Act.
No
Section-
judicial officer.
No judge,
No.
judge not to try a suit in which they are interested. No judicial officer
Or
of authority of customer
customer, okay.
shall try.
Yes. Cannot be judge of his own cause. And it is in violation of the provision under section 17(3) or 17(1) of the Arunachal Pradesh Civil Code Act 9 and 2021, whereby it is provided that no judicial officer or authority of customary court shall try any suit to, or in which she is a party or personally interested. Stop. Furthermore, Malani Council for the petitioner submitted 3. Yent Tiring is a political interpreter who is a government employee. Therefore, he cannot act as an arbitrator in the case as it is prohibited under law. If further, while referring to the decision of the decision of the division bench of this honorable court, in writ appeal number 36 APF. Okay, this is okay. In Tadi Tabang and others versus Gumjum Ango and others, reported in 2009 for GLT 626. Submitted that the role of, just a minute. The duty of the political interpreter is appointed under which section? Section 5.
No. He's not. He's
under
governed by.
section
He's
5.
purely government employee.
Okay.
Different
The
recruitment rules.
duty of the political interpreters is only to assist in the decision making process by giving their views on the administration when sought for by the village authorities. Therefore, he cannot be appointed as the arbitrator in the case. Okay, stop. Issue notice. Call for the relevant records. Stop. The petitioner shall take steps upon the respondents by a registered post with AD within a week, AD as well as by a user process within a week from today. Stop. Para. In the meantime, come. And in the interim, it is provided that the it's a proceeding.
Proceeding, my lord.
So
My lord,
we can say the proceeding started. It is a proceeding. Not
proceeding-
yet started or what?
Not yet started, my lord. If, my lord, this impugn order, last order, if it is suspended, my lord, it will suffice, my lord. Because it's rescheduled to be held on 27, if it is
Okay, the
suspended.
last
Operation-
order, last order, 9/5.
Yes, madam. If it is suspended, then it will suffice, madam. Operation of this interim order,
Okay,
this impugn order.
Okay, the operation of the impugn order. Impugn mail is called mail order.
Yes, mail.
Well, let us see where is the page? It's mail order.
At page 74, madam.
They said it is a mail order,
Yes, madam.
but this is actually someone only, it appears.
Someone, by this order, it is rescheduled, madam. This is
Hmm.
both, my lord, at page 50
Okay.
and page
Okay.
74, madam.
So then page 50 is not required because thereafter it has been rescheduled on. For
Yes, yes, madam. But arbitrator and this, the same, madam.
Okay.
Remain as same.
Then both then, huh? Page 50 is the operation of the order dated, mail order dated 24 to
2025
2025
and May,
and
9 May.
the extension of mail order dated 9/5/2025. Sale remain state till the next returnable date. Huh? Stop. List is matter after 4 weeks.
Madam.
Declare. Keep it, huh? Yes, you will also, this is a bail application, fourth bail application. Fourth bail application. Fourth bail application? Yes, fourth time. This is filing for the fourth time. Fourth time? Yes. The first. When he was arrested? I was arrested merely on the disclosure statement made by. No, no, when he or she? He. When he was arrested? Last year, 2024, in the month of April. Month of April? April. 1 month already. For what offense? What offense? NDPS Act. NDPS, what is the maximum punishment? Maximum punishment, 10 years. Intermediate? Yes. But
Okay.
your lordship, nothing was recovered from my possession.
So why it was rejected 4 times? This is, it was rejected by the trial court only?
No, it was rejected by the special judge.
That is what I'm
Yeah.
saying.
Yes.
Special judge.
Yes.
4 time rejected.
No, 2 time rejected.
Okay. And 2
On
time
last
by,
occasion, when the subsequent bail application was filed, it was not passed, order was not passed. It was kept reserved for almost 2 months. Then we approached this high honorable court for the direction that the order may be, necessary order may be passed by the session judge. So accordingly, it was the second bail order on second bail application was passed. It was rejected on the ground, on common ground. It was by observing that page number 16.
that he is connection
He is you know, main connection with the case. Yes. And he is main supplier.
Your Lordship, here, point number 4. I have perused the record and seen that the accused Arif Aslam is the main supplier of
Yes.
narcotics and sold drugs in presence of in case and receive of rupees 35,000 in case and rupees 15,000 through online.
You are reading which page?
No, Your Lordship. During the page number 16.
60.
16.
16.
Yes. The rejection order.
Yes, through online, and he is peddling the drugs from Assam to Arunachal and taking into consideration. Okay.
Your Lordship, charge sheet has been filed.
Charge sheet already filed.
Yes.
This rejection was this rejection order was passed after the charge sheet has been filed.
Yes, after the charge sheet has been filed. During the
He is the best person, the trial court, he is the best person.
Your Lordship, in the charge sheet, the IO has brought nothing on the record. They
Maybe, but then you see the trial court after perusing the record has rejected, and on the charge already framed must have been framed.
Yes.
Trial evidence also recorded.
Evidence yet to be recorded.
Not yet recorded.
Not yet recorded.
When the charge was framed?
Charge was framed.
When have you annexed?
Charge sheet. Charge was framed on 8/17/2024.
Okay, then evidence must have been recorded by now. You are
No,
not
no.
updated, it appears.
No, Your Lordship, I'm in the custody. It's still.
You understood.
My statement
But
is-
then what is the status of the case? What I'm asking? Status of the case.
Status evidence-
Trial.
Trial.
Evidence, how many evidence have recorded?
Not yet,
Not yet.
Yes.
But then subsequently you have filed 4 applications.
Yes.
All the 4 applications have been rejected.
No, two application has been rejected, and the third application was filed before this
It
honorable
was
court.
okay. It was disposed of on merit only after considering the
Yes, it was
okay
merit.
considering the application on merit. Then what is the new ground that you have taken this time for coming before this court?
Your Lordship, here if we peruse the arrest memo, Your Lordship.
Understood. But then what is the new ground you have taken? On this ground, on merit, on consideration of the case on merit, his bail application was rejected because saying that he is the main accused. He supplied. He is the supplier from Assam to Arunachal and taking those money. With that observation, your bail application was rejected. That means the case was considered on merit. Now my question is, that was also disposed of only after filing charge sheet, after framing of charge. Now, what is the new ground that you have taken this time for filing this bail application before this court?
Your Lordship, the new ground I have taken that the trial is likely to be take a longer time. He has already spent 1 year, 2 months in the judicial custody. Because, Your Lordship, previously the evidence was fixed.
No, it appears that you are not updated because Mr. We'll call for the then scanned copy.
Yes.
Is not updated. What is the status of the case?
Yes.
Because no new ground, unless there is a new ground, it's very difficult. And if there is a new ground, some evidence has been recorded. If there is nothing, it can be granted bail.
Yes.
If there is anything, it's of course the trial court is the best court to consider the bail
Yes.
on merit.
Scan copy of this here.
Let us see. Okay, we'll call for the record. Okay.
And
Mr.
this petition cost title is defective. Front page it
What?
says Solom Islam is a complainant.
Total Islam.
Solom Islam is authorized person by the accused. first page of the petition, it's written complainant.
See, the accused, you are for Solu Islam.
Solu Islam.
He is the applicant.
Yes, yes.
He is the applicant, Solu Islam.
Yes. Yes.
What is the name of the accused then?
Arif
Arif
Islam.
Islam.
Where is his? Praying for granting of bail. Arif Islam.
Arif Islam.
And who is this Solu Islam?
Solu Islam is the brother.
Brother.
Brother of the accused person.
Okay.
Posted there is no mention of Arif Islam. Posted.
Hmm?
Posted there. There is no mention of accused name.
No, in the course title, it's there.
It's
An application for release granting bail to accuse Arif Islam, who was arrested. Is there first page here? First page. Is there? Mr.
M. Kamcham.
M.
Kamcham.
Learned counsel for the petitioner. This is an application file under section 483 of the BNSS 2023, praying for granting bail to the accused Arif Islam, who was arrested by the Bandadwa police in connection with the Bandadwa PS case number 32/2024 under section 21B of the Narcotic, Drug and Psychotropic Substance 1985. Stop, huh? Call for the stain, okay. Call for the scanned copy of the trial, copy of trial court record. Since Mr. Tadov, additional PP is appeared, has appeared, no notice need be issued to the state respondent staff. List this matter. When can this matter be listed? Mr. Tadov?
Yes.
When can the matter be listed? List this matter again on June 2.
11 June.
Why 11 June? Okay, this is a bulk. Any
Today is 23. That means
1 week. Okay, then 9 June. Monday. Okay.
We have some difficulty if fixed on Monday because
Okay.
CD or anything else.
Okay, okay,
whatever
okay. And 1 working day ahead
Yes,
of the case fixed.
on Tuesday,
You
10,
can-
10.
Okay, okay.
Your Lordship, may I please come to page 39, Your Lordship.
What is that?
The ground of arrest has not been communicated to the accused person. Ground of arrest.
Arrest memo here.
Arrest memo, it is arrest memo. At the time of the manner in which they have arrested.
Have you challenged on that ground?
Yes, Your Lordship.
Where?
Page number 8.
At the time
Where
of
I-
submission, you just make a submission that ground note. Page?
Page 8, para 8.
What the police are doing, and then you see, in other case also on this ground, some 2, 3, 4 accused probably has been released. In the very serious case, what the police are doing. Okay, so at the time of hearing, you take this plea also.
Problem.
Okay.